this. All right. So this is bankruptcy options for consumers from Legal Services of Northwest Jersey. I'm going to start with this disclaimer. I'll have to repeat it later for people who show up later. I'll just make sure that everybody heard the information. But again, this is information. It's not legal advice. And the reason we say that is because legal advice means you're talking to a lawyer directly and presenting the facts of your specific case and circumstances, and the lawyer can then give you advice specific to you. So because we're speaking generally, this is legal information. The law is always changing, and that is why as time goes on, you'll need to check in with your lawyer as to the information in this webinar today. The information pertains to New Jersey, even though there's federal bankruptcy law, which Gary will be talking to you about. There are New Jersey aspects in which New Jersey law intersects. We are licensed to give legal information and advice in New Jersey, but if you are outside of New Jersey, you should contact a lawyer licensed in your own jurisdiction. Your attendance does not form an attorney-client relationship between you and us. If you apply to us for services, at that point, an attorney-client relationship would begin. And I say that because if your appearance and attendance at this webinar is not privileged or confidential, so you should not be sharing confidential information publicly in the context of this webinar or with us until we begin an attorney-client relationship. We are Legal Services of Northwest Jersey. What we do is provide equal justice in our 5 counties of Hunterdon, Morris, Somerset, Sussex, and Warren. And our legal services are free for eligible people. So people apply for services, and if they have limited income and assets, they may be accepted. We also have legal projects, such as for people age 60 and older, for veterans, for people affected by HIV/AIDS. And now we also have expanded eligibility for housing cases in Morris County and Somerset County. Our teams provide legal services in a number of areas. So even if you decide bankruptcy is not right for you, there may be other services that you would need to apply to us for. Our consumer team handles bankruptcy matters and other debt collection defense matters. Our housing team handles both foreclosures for property owners and tenants' rights matters, including evictions. Our public entitlements team handles applications for public entitlements and aid, unemployment insurance benefits, welfare benefits, food stamps benefits, and SSI, SSD benefits, Social Security, disability benefits. And our family team does family law, the full range of family law. And we also have a team, autonomy team, which handles life planning documents, which would include wills, healthcare directives, and advance and powers of attorney. I'd like to introduce Gary Silvestri, one of our staff attorneys today, who will be presenting the information. He practices in the areas of consumer bankruptcy and landlord-tenant law. He started out his legal services career in Ocean Monmouth Legal Services and was a supervising attorney of the Ocean County office. He returned to public service at Legal Services Northwest Jersey after practicing for a time in a private law firm. And he has also been an educator and has lectured at Legal Services in New Jersey. He's trained lawyers throughout the state in legal services for many years in the areas of consumer law and bankruptcy. He's an adjunct professor at Ocean County College, teaching business law, legal writing and research, and introduction to paralegal studies. And he's been awarded numerous awards for his career service to people in our state. And with that, I'm going to turn it over to Gary Silvestri.
Okay, so we're basically going to go through some of the basic types of bankruptcy, and so that you have information and whether you even need it. And then we'll also do a little interplay with some of the state law, so you could understand what can happen to a person who owes debts, and whether you even need to file a bankruptcy because of there may be some protections under state law. So basically the first slide tells you that bankruptcy relief it's statutory relief, it's federal law. Okay, so it's found under the United States Code, and it's a right that you have, a federal right that you have to seek relief for a fresh start. Okay, and it allows you. There are different types of bankruptcies. We're going to be talking about them. We'll talk about a 7, 11. There's even a 12 and a 13. We'll be talking about them and what the different types are. So this is just an overview. There are people that we have people that contact us that want to file bankruptcy, and based on their facts, they don't really need to file a bankruptcy, and I'll talk about that. So there's no need to go through all that work and get what's called a discharge of your debts when you don't really need it, because there's nothing that they can do to you in the long run, at your present situation. So we'll just mention that into play. Okay, so bankruptcy falls under it's called BAPSIPA, which is it's a Bankruptcy Abuse Prevention and Consumer Protection Act. So the old bankruptcy law was prior to 2005. There was a big change in 2005. Just to give you a little bit of background, the creditors being the creditor lobby, like big credit card companies and mortgages, were basically arguing and pushing to change the law because they thought that people were discharging debts when they could afford to pay it, right? Or that they were running up credit card debts and just filing a bankruptcy just to discharge the debts, all right? And they thought this was abuse. All the data shows that is not what the case is. The case is most people need to file for relief because of something happens. They have catastrophic medical bills, they lose their job, there's a divorce, something along those lines. So there really was no abuse going on, but the legislature, Congress passed the change in 2005, and it did make it a little more difficult to file a bankruptcy, but it doesn't paperwork wise, but it's still, it's still accessible to pretty much everybody that fits under the guidelines. We can go to the next slide. Okay, who can file? Talks about natural persons. You can file what's called the Chapter 7 and 11. We'll go into the different types, the 12 and a 13. As a bankruptcy attorney, like if I'm talking to a client, I have to explain the different types of bankruptcies. It's required that a bankruptcy attorney do that so that you have you can make a knowledgeable and understand choice as to what would be best for you. A Chapter 11 normally is a reorganization. It's normally for businesses, but it can also be for people. And then there's a Chapter 12, which is basically for farmers, and a Chapter 13 is a readjustment of debts for a wage earner that has some money coming in where they can do a repayment plan over 3 to 5 years. Now, normally you say, well, what's the difference between a 12 and a 13? A 12 is normally for a farmer. Okay, that is that someone who the most of their income comes from a farming occupation. So a 13 allows for a repayment plan to catch up and also to repay over a 3 to 5 year period. A 12 is for a farmer that's having problems with their farming, his or her farming operations, and it allows them that chapter to file under. Okay, we go to the next slide. Okay, so what chapter is best? What bankruptcy chapter is best for you? And the slide basically is letting you know that bad things happen, even can happen to anybody. And you could have a loss of a job, a sickness, a family breaks up, whatever. To give you an idea, a bankruptcy has been around for a long time, and the idea of debt relief has been around over 1,000 years. Okay, so some of the first written laws, Hammurabi's Code, talks about debt relief. And a classic example would be a farmer that would get credit extended to them by saying, look, I'll give you money. I will give you, sell you seed. You don't have money for it. And then when your crop comes in, you'll pay me with your crop. Okay. And the classic example was that, let's say, lightning strikes the field, sets it on fire, all the crops destroyed, and now that farmer can no longer pay the merchant who sold them the seed. Okay, so the idea of debt relief back then it was every 7 years, and Hammurabi's code, I believe, was in that the 7 years said, look, this can happen, things happen, it's unavoidable, and therefore you're entitled to a relief and a fresh start and to wipe out that debt. So it's been around for a long time, and it's been codified into federal law for us, right, in the United States. Okay, let's go to the next one. Okay, so which chapter's best? Chapter 7 is basically, any bankruptcy is going to offer you protection from creditors, all right? And if you have a loss of income, employment, you're retired and your income drops and you can't afford your whatever bills that you were paying, your expenses, and you fall behind, it allows you to get relief to discharge those debts and to get a fresh start, okay? Now, what happens when you fall behind on your credit cards or other bills, okay? Well, what we're going to look at first is if we have a secured creditor, if you don't know what the difference is, the classic example is like a car loan. You have a car loan. What can happen if you don't pay on your car loan? Well, technically, they can repossess the car. They don't even have to go to court to repossess the car because they have a lien or security interest on the car. So it's on the title. And so they can come and repossess the car, okay? On a house, they'd have to file something. If you have a mortgage and you fall behind, the mortgage is secured to the house. They'd have to file a complaint. They can't repossess the house. They have to file a complaint and go into court and get a judgment of foreclosure to actually sell your house in a sheriff's sale if you fall behind on your mortgage. All right, now with a car, just like with a car, they can threaten repossession. They can try to repossess, but under state law, they can't breach the peace. So like if a repo person comes to repossess your car and you go outside and you make a big stink they can't, your car is in the garage and it's locked. They can't break in and get it. They can't breach the peace. They have to withdraw, and then they have to go to court and they have to get a court order to go after the car. But this is a difference between secured creditors and unsecured creditors, because unsecured creditors are ones that do not have a lien or some form of possessory interest in the item. So unsecured debt is pretty much everything else: credit card debt, medical bills. You owe you owe back rent. So most individuals have what's called unsecured debt. Okay, if it's unsecured, they don't have recourse because against real property because they don't have a lien, personal property. They don't hold any title or anything like that, like a car loan. So they would have to go through the court process and sue you in order to go after those assets that you may have, okay? So they can't just come to your residence. They can't, take personal property, seize bank accounts, garnish wages without a court decision, okay? They have to sue you and get a judgment, okay? And where they're suing you, you can't go to jail. There's no debtor's prison. It's basically where someone is trying to get a judgment so that they can try to collect money. And we'll talk about the different ways that they can collect. Now, a lot of people, we have clients that want to file bankruptcy because they're getting debt collectors are contacting them. They're constantly harassing them. They maybe even be abusive or aggressive, and they just can't, after a while, they just can't handle it or deal with it. And they may want to consider saying, well, maybe I need to file a bankruptcy, wipe the debts out, and that will pretty much stop any attempt to collect on the debt. So Chapter 7, it's most often used to protect from creditors like by discharging unsecured debts. So most of our Chapter 7s are just unsecured debts. Let's face it, a secured debt is this: if you have a car loan and you file a Chapter 7, if you don't pay on your car loan, since they have a lien on the car, eventually down the road, if you default, they can repossess the car, right? So most people that are doing sevens or have unsecured debt, if they're current on their car, then they just keep paying on their car loan, even though they're filing a seven, and they wind up discharging their credit card debt. And technically, they do wind up discharging the debt. Most likely they'll discharge the debt on the car. But if you don't keep paying on it, even though you discharge personal liability, they can repossess the car, all right, if you default. Okay. Okay, so when you file a Chapter 7, you actually are telling a trustee, that's someone who administers your estate, this is everything I own. This is everything, okay? This is my car that I have, that I don't have a lien on, but it's a car I own. This is my furniture. This is my jewelry. This is my tools of trade. This is my right to sue somebody for personal injury. Let's say I was injured, I slip and fall, all right? That is a right that you have. So you have to include all of that information in your bankruptcy petition. You have to disclose everything, okay? Now, personal property. Normally, let me just go into state law a little. Under state law, you have an exemption for personal property. Those are like things that you have, like furniture, bank accounts, things like that, okay? Under state law, New Jersey law, there's $1,000 exemption. I guess I jumped to the other slide here. There's $1,000 exemption, which is not much. That's why when people have assets that they want to protect, and it's more than $1,000. So let's say you have a car that's worth $5,000 and you don't have a loan on it. You own it outright. If someone sues you and gets a judgment, they can try to levy on that car. Technically, they could try, once they have a judgment, to try to collect by going after the car. It very rarely, if ever, happens. But I'm just saying that, or you have a bank account and you have wages in there and there's $3,000 in there. Well, under New Jersey law, you have $1,000 exemption. So you can apply $1,000, but that still leaves out of that 3,000, 2,000 left, and the creditor can get it. So if you want to protect that judgment, creditor can get it. If you want to protect those assets above the exemptions that New Jersey gives, which are not much, then you consider filing a bankruptcy, because you can keep more items and you can get relief and discharge your debt. Okay. So some of the things are listed on here. It permits a debtor to keep up to equity in a house of up to $25,150. That's their residence, okay, that they reside in, okay? And if you're a married couple, it's double. So if a married couple, they're both on the deed, so it's doubled. Equity being this: if I have a house that's worth $300,000, I have a mortgage on it, and the mortgage is $250,000. And I'm married, husband and wife own it. Well, then what happens is if you took the mortgage, if you sold a house for $300,000 and you paid off the mortgage, which was $250,000, $50,000 is left over. Well, that's $50,000 cash, arguably. How do you protect that? Well, you can protect it by filing a bankruptcy. You can wipe out your credit card debt, and you can protect that equity by discharging the debt, and you claim that exemption so that a trustee will not sell your house. Now, if you have a house that's worth a lot of money, let's say $500,000, and you have a $300,000 mortgage, you have $200,000 in equity. The exemption is not going to cover it in a Chapter 7. And so if you filed a Chapter 7, a trustee who is supposed to administer your estate and sell assets or liquidate to sell to pay creditors is going to say, this is not exempt. Your equity is not exempt. There's another $150,000 in excess equity here, and a trustee can wind up selling your property in a bankruptcy, and selling it and using it to pay your creditors. Now, that's why anyone contemplating a bankruptcy, there are people that will try to do it on their own, pro se. I don't recommend it. I have seen people in bankruptcy court that file their own bankruptcy, not aware of the exemptions, not aware of what their property was worth, and a trustee telling them, I am going to sell your house. And you can imagine the shock that that person had. When they're at a hearing, that's what happens, and they say, well, I thought I was going to be able to wipe out my debts and keep my house. Well, they didn't talk to an attorney. They filed a bankruptcy and they had too much equity in their house. And the trustee was now saying, I have a duty to administer the estate so that it's fair to creditors and everybody. And I am going to sell your house because it's not exempt. And there's too much equity. And so that's why any of these situations like this, you should always consult an attorney. Obviously, if you're eligible for us, we're free. So, there are certain other items that are exempt under New Jersey law. Okay, so there's no under New Jersey law, there's no exemption for a residence. So in bankruptcy law, you have an exemption for $25,150 for equity in your residence. In New Jersey, we have no residence exemption. So some states have unlimited residence exemptions. New Jersey doesn't have anything. So that's why if you have equity in a residence and you have creditors coming after you, and that equity is not above the bankruptcy exemption, you may say, look, maybe I'll file a Chapter 7, wipe out the debt, save what equity I have under the $27,150 and protect that equity and wipe out my debts. Other things that they cannot touch in New Jersey, they can't, a judgment creditor, they can't go after 401ks or IRAs. They can't go after unemployment or Social Security. Social Security income is exempt under federal law. All right. So if you have someone that has a judgment in New Jersey, they can't collect from your Social Security. They can't, for child support, yeah, they can get Social Security. But regular creditors, unsecured creditors that then file and have a judgment against your credit card, they can't touch your Social Security. They can't touch unemployment. They can't touch veteran benefits, public assistance. They cannot touch pensions, all right? Just because pensions are exempt under federal law, all right? It's a trust and it's exempt under federal and New Jersey state law. So the creditors cannot get at that, okay? You have, in bankruptcy, you have a $4,000 exemption for equity in a car, okay? So remember my example in state law, we talked about there's only a $1,000 exemption. If I have a car that's worth $4,000 and someone sues and gets a judgment and then wants to put a levy on my car or put a lien on it, all I have is a $1,000 exemption under New Jersey law. So how do I protect my car? Well, you protect your car by saying, maybe I need to file a bankruptcy and protect the car because under New Jersey under the federal bankruptcy law, I have a $4,000 exemption for equity in a car. Now you might say, yeah, but I own a car outright and it's worth $10,000. Well, if you look further down on this PowerPoint, in bankruptcy, if you don't own a house, or let's say you have, you can use 1/2 of your unused residence exemption towards anything else, okay? So that 1/2 I could stick on a car. So the attorney, he or she, would look and manipulate the exemptions to cover your assets in a Chapter 7 so that you would not lose anything. Obviously, if I have someone where I say, look, I can't cover it, you're going to lose it, there's a problem here. And then we might have to talk about a different type of bankruptcy for you. But if you look, you can see on the very bottom, it says there's $1,325 in any property, plus the unused exemption on your home up to $12,575. So technically, let's say I have a car that's worth, I don't know, $15,000 and I don't have a loan on it. So what happens is I can take the $12,750. I can take the extra, that $12,750 and I can apply that, okay, towards the car plus $1,325 plus my $4,000 car exemption. I can add all those exemptions together and I can actually keep a pretty nice car. At least in my book, it's a pretty nice car because my cars are not worth that. So, all right, so let's check out the next slide. Okay, what property is most often sold in a Chapter 7 case? So Chapter 7 is a liquidation. You're telling your trustee, this is everything I own, all right? Who's supposed to manage your estate and liquidate it, sell it to pay creditors. So you don't want to file a Chapter 7 if they're going to liquidate some of your assets. So you want to make sure that all your assets are exempt and the trustee who's mustering all those assets together, to try to sell to pay creditors will not sell any of your assets. Okay. So if you have real estate that we just talked about with significant equity above that exemption, you don't want to be filing a 7 unless you plan on losing your house. Okay. Stocks or bonds, securities, you have to look at what the value is. Unless they can cover it under an exemption, you could lose that. Valuable cars, we just talked about that, without a lien. If you have a car that's worth $50,000, you're not going to be able to exempt it. All right. So the right to sue for any reason, if you have a personal injury claim, okay, where you were hurt, there's an exemption for that, but it's a certain amount. And if it's not, if you can't cover it with the exemption, a trustee literally can take over that personal injury case and basically carry out the case until they get money and use it to pay creditors. They can actually get it so that if you have an attorney representing you on a personal injury case, and that attorney doesn't then cooperate with the trustee, they can actually move to get the attorney removed from your case and they get someone else to handle the case so that they can collect money and use it to pay creditors. Okay, so everything that you own, all right, is up for sale. Okay, so that's why you have to list everything down. You can't fail to do this, deliberately fail to disclose assets, because then you could be charged with a bankruptcy crime. It's punishable by imprisonment and actually a loss of your discharge, which means none of your debts can be wiped out. So you don't want to hide assets. You have to list everything down. Other things that might not be exempt, you could have expensive jewelry. You could have, if you have property you don't live in, like vacation property or something like that, that's not exempt. Remember, the exemption's for your residence, all right? And it's only a limited amount, okay? And the right to inherit within 180 days. So technically, if you file a bankruptcy and your great aunt Martha left you something, she dies within 180 days, it goes into the estate and they can use it to pay creditors. If great aunt Martha dies after 180 days, guess what? It's all yours. The creditors can't touch it. It's outside the 180-day period. But you can have that happen where someone passes away within 180 days, you fell into bankruptcy and you get a substantial amount of money. That trustee, he or she, is going to go after that because it's now property of the Chapter 7 bankruptcy estate. Okay. Okay. Exceptions to discharge. This isn't necessarily all of them. It's just, we're putting some of the major ones in here. Okay. Again, every individual, you have to analyze each thing individually. Okay. So most debts are dischargeable or can be wiped out in a bankruptcy, in a Chapter 7 bankruptcy. Okay. But there are some that are not. So if you owe taxes that are over 3 years old, you owe the IRS, they are normally non-dischargeable. But if they're more than 3 years old, all right, and you filed a timely return or you didn't commit fraud on the return, then you can discharge those taxes. But normally taxes are non-dischargeable. Creditors not listed. So let's say you have someone that let's say you assaulted someone and they filed a personal injury case against you and they're trying to recover. You beat up somebody and they sued you for injuries, okay? And you didn't list that creditor. Well, that creditor, if it's not listed, may not be discharged, normally would not be discharged. So you have to list all your creditors down. You can't pick and choose, okay? Now, there are some exceptions to that, but I'm not going to go into it, where it's an unsecured creditor and you fail to list them, but I'm not going to go into that. Fraud is a fiduciary or embezzlement. What's that? Embezzlement's where you take control over someone else's, you have the authority to handle someone else's funds, but then you use it for yourself. Like a bank teller that takes money into the bank, but instead of putting it in a drawer, puts it in their pocket. That's embezzlement, okay? In that situation, they had a right to control the money, but then they took it for themselves. That would be the easiest way to talk about embezzlement. That, or a fiduciary, you're supposed to manage someone else's money and you take it. That's not dischargeable. Domestic support obligations, child support, all right, alimony is non-dischargeable, okay, in a Chapter 7. Malicious or willful and malicious injury, It's not dischargeable. You go outside and you beat somebody up and they're going to sue you. It's willful, it's malicious, it's not dischargeable. Fines or penalties normally owed to a governmental unit are non-dischargeable, okay, in a bankruptcy. Student loans, unfortunately, student loans are normally non-dischargeable in a bankruptcy. There is, one exception. It's very hard to prove. It's if it's an undue hardship on the debtor, the person filing the bankruptcy, and it's a three-pronged test, and it's really kind of tough to actually discharge a student loan. Sometimes there's other non-bankruptcy ways of trying to deal with student loans. Debts through drunk driving. Example, actually the bankruptcy section that talks about this talks about driving while intoxicated, flying a plane, or navigating a boat. So if you're on a jet ski and you're drunk and you hit somebody and you hurt them, you have a problem, all right? You're driving a car and you're drunk and you cause an injury, it's a death or personal injury, it is non-dischargeable in a bankruptcy. Now, I'm going to tell you right now, I have had clients that have hit telephone poles, okay? And they're drunk. Well, guess what? It says if it's a death or personal injury, that's not a death or personal injury, that's a property damage. So unless someone was up on top of the line working on the telephone lines, it's just a telephone pole. Well, if you hit a telephone pole and knock it down, they're going to want to get paid. And if they sue you and they don't get paid, since it's a motor vehicle accident and you have a judgment against you, they'll suspend your license. So guess what? You can file a bankruptcy. You can discharge that liability for the telephone pole because there was no death or personal injury, and your license is no longer suspended. Okay, so that's an example. That's an example. Criminal restitution is not dischargeable. You commit a crime, part of your sentence is you make the victim whole. You have to pay the money. Debts to pay non-dischargeable debts. What's an example of that? I want to file a bankruptcy, but I owe taxes. I owe taxes from a year ago. Well, my attorney told me that's not dischargeable. So maybe I'll pay that with my credit card and then file a bankruptcy and I can discharge the credit card debt. Guess what? That's a little problem. Why? That's a debt incurred. That is a debt to pay a non-dischargeable tax debt. And therefore, the credit card company may object to you getting a discharge, saying, you just use this to discharge a non-dischargeable debt, and we're not allowing that, okay? Debts through false pretenses or fraud. This is where you scam somebody, or even you put out an application on a loan and you lie about your income, and then as a result, they file a complaint in bankruptcy court. They literally file a separate complaint saying you shouldn't be able to wipe out that debt. It's fraud, okay? Look at the very bottom of the PowerPoint. Now, what about people that say, look, I want to file a bankruptcy, but I always wanted that living room set. So what I do is I go out and I buy a $2,000 living room set. And now what I do is I say, you know what? Now I'm going to turn around. I'm going to file a bankruptcy. And I'm going to blow off that credit card debt. And I got a living room set. And I don't owe anything on a credit card. Well, that's what they're talking about here. Okay. Fraud. There's a presumption of fraud if you load up on a credit card prior to filing a bankruptcy. A presumption means the creditor has that presumption. If they file a complaint in bankruptcy court, they may be able to prove that you can't discharge it because it's fraud. It's one of the non-dischargeable ones listed, okay? So to rebut that presumption, you don't want to fall within that period. So what are we talking about here? We have consumer debts in excess of $750 from a single creditor for luxury consumer goods. Well, that's not food, okay? And it's luxury consumer goods. You go out and you get a Rolex watch, and then you turn around, file a bankruptcy and blow off the credit card debt. That's a luxury consumer good. It's more than $725, right? It's not dischargeable, okay? If it's within the time period, which we're talking about, which is 90 days. So if I had someone that loaded up on a credit card and they want to file a bankruptcy, just think about it. And they charged $900 to get, I don't know, a mink coat. That's a luxury consumer good. Regular clothing might not be, but regular, okay? Well, then I tell the client, you know what? We have a problem here. Why don't you wait till after 90 days and come back and see me? Why? Because now they're outside the 90-day presumption that it's fraud, and it makes it a lot tougher for the creditor to prove that you committed fraud, okay? So that's just called good bankruptcy planning, okay? All right, and so Chapter 13 is used when you have real property or you have, you know, a house or a condominium. Usually people who file 13s, it's for an individual that has income and they can reschedule their debts over a 3 to 5 year period. So what does that mean? Classic example is you fall behind on a mortgage, okay? And as a result, you can't pay your mortgage payments and you're threatened with foreclosure, okay? And then what happens is, because you lost your job and now you got your job back and you can afford to pay your mortgage, but you want to pay a little bit toward the arrears, and the mortgage company says, no, you got to make it all current. We want a lump sum, otherwise we're going to foreclose, okay? What do? Well, now you have some extra, you have a little bit of disposable income left. You can afford to pay your mortgage payment, your regular mortgage payment, and you can take those arrears and you can pop them into a Chapter 13 plan over 3 to 5 years. It can't be more than 5 years. So now, because they wouldn't work with you, you can force them to take a payment plan over 3 to 5 years to pay those arrears, okay? Now, Chapter 13 discharge, all right? Normally, there used to be what used to be called a super discharge in bankruptcy, where you could discharge more debts than you could in a 7. And that pretty much it's been gutted quite a bit by the 2005 bankruptcy code, but there are some things that are still dischargeable in a 13. What's a 13? You're making a payment plan over 3 to 5 years. Because you're making a payment plan and you're trying to pay your creditors back, cure arrears on a car loan or on a mortgage, and you may pay very little towards your unsecured debts, like a credit card. You might pay 5 cents on a dollar if you do that, okay? What it does is it allows you to discharge most of these debts, but there are some debts, additional debts that are not dischargeable in a 7 that you can discharge in a 13. And that's willful and malicious injury to property, okay? Talking about property, okay, is dischargeable. Marital debt settlements. Now, alimony and child support, you can't discharge in any bankruptcy. What they're talking about is where you have equitable distribution in a bankruptcy. What does that mean? You get divorced and you agree to pay all the credit card debt. And both you and your ex are on the credit cards, and you agree to pay the credit card debts as part of the equitable distribution, okay? And then what you do is you turn around, you file a bankruptcy, and you wind up wiping out those credit cards. That is dischargeable in a 13. It is not dischargeable in a Chapter 7. So if you agree to pay those credit card debts in a divorce, you can't get rid of it in a 7, but you can get rid of it in a 13 because you're attempting to make a repayment plan, okay? And certain fines or penalties might be dischargeable in a 13. That has to be, you have to analyze that case by case. We talked about, basically we talked about taxes are still taxes. If you're not within that 3-year rule, you still can't discharge them in a 13. But debts to pay non-dischargeable tax obligations, it appears that those would probably be dischargeable in a 13 where you use a credit card to pay. And even then, there may still be an issue though. Okay, so let's go to the next slide. Now, what this is talking about is there's a median income. All right, there's a means test to file a bankruptcy. This is part of the change in the code in 2005. All right, because they thought people were making enough money that they could afford to do a 13 payment plan instead of a 7. So what happens is they go by median income in your state. And this means test can determine whether you have to file a 13 or a 7. Okay. Now, New Jersey has a pretty high, it's expensive to live in New Jersey. So the means test in New Jersey is basically, these are found on a court website. And what you do is you put it in and how many people are in the family, and then it comes up with a number. If you're under that number, you're in a safe harbor, they call, and you can file a Chapter 7, all right, where you can discharge your debts without paying anything back, okay? But if you're over that, then they're going to say, look, this is abuse. You're over this means test, and therefore you have to file what's called a Chapter 13 and do a payment plan, okay? So, all right, Chapter 13, again, you have a loss of income, you have an illness, you have a family, a breakup, and there's a divorce, and there's a loss of income there, all right? And you want to resume the payment, or a car loan you fall behind, you don't want them to repossess it, you file a Chapter 13, where we talked about this, and you reschedule the debts over 3 to 5 years, okay? That's 60 months is 5 years, okay? And you still have to make your regular monthly mortgage payments in a 13. You're just paying the arrears in the plan, or your regular car payments. And then if you have any arrears in the car, you would catch that up in the plan. And, the trustee, there's a separate trustee for Chapter 13. It's different than a Chapter 7 trustee. And they actually get a fee for administering and paying all their creditors through the plan. It's usually around 10%. So. But you have to have income to do it, to make it feasible. That's all right. We can go to the next slide. Okay. Do you even need a bankruptcy case? How are we doing on time? We got about 15 minutes left. Okay. There are people that want a bankruptcy, and as a legal services attorney, I'll tell them, look, you don't need a bankruptcy. Why? Because first of all, you can file a bankruptcy at Chapter 7 once every 8 years. And get that discharge and that fresh start, okay? And a Chapter 13, you can file it once every 6 years, okay, to get a discharge, a Chapter 13 discharge. Now, if you're someone that has an income source that they cannot touch, okay, and let's say you lease a car, you don't own the car, okay, because you lease it, and you don't have a house, you rent, and your income source is exempt. What is your income? You're retired, you're on Social Security. Well, remember, Social Security is exempt under federal law. It doesn't even have to be bankruptcy law. Under federal, non-bankruptcy law, Social Security is exempt. They can't get a wage execution. They can't get it. You don't have a car because you lease a car. You don't own a car. You have a car, but you don't own it. So there's no asset there, okay? And the money that you put in the bank account is all Social Security direct deposit. So it's still exempt. It stays exempt, okay? That's the argument. And your furniture in a forced sale, remember there's a $1,000 exemption for goods and chattels, furniture, goods and chattels. It's not worth much in a garage sale. So you're what's called collection proof. They can sue you, they can get a judgment, but they can't get a wage execution. They can't go after bank accounts because everything's exempt that you have. You have a $1,000 exemption under state law. You're basically collection proof. There's no need to use up that bankruptcy discharge that you're allowed in a Chapter 7 once every 8 years. Why waste it? Especially if you're going to incur additional debts. If you have a situation where you're in a problem and you're collection proof, why file a bankruptcy? Why not wait? Maybe things will get better and maybe you'll have even more debt, and then you can file and discharge all that debt. Okay, because post-petition debt that arises after the bankruptcy is not dischargeable. Okay. Okay, so you don't go to jail for owing debt. There's no debtor's prison, but basically there are situations where they're trying to collect on the debt. I don't know if this is in the next slide. Is the information subpoena in the next slide? Yeah, it is. Okay. What happens is when someone gets a judgment, sometimes what they send you is what's called an information subpoena, okay? It's 17 questions that they ask you to answer within 14 days. What it is the judgment creditor, they sue, they have a judgment. They're trying to collect on debt. So they want to see if you have any assets or anything they can get, a job. So they ask you questions about, do you have a car? Do you have a job? What's your source of income? Do you have assets more than $1,000? Other, do you have bank accounts? And you have to fill this out. And they give you 14 days to do it. Now, what happens if you don't fill it out? Well, first of all, it's a subpoena. You're supposed to answer it. Okay. What happens if you don't? It's called civil contempt. So that creditor can actually bring what's called a motion to enforce litigants' rights, which is to say, you didn't answer the subpoena, and therefore I want you to answer it. Otherwise, we're holding you in contempt. Now, what does that mean? It's civil contempt. It's not a crime, but it's civil contempt, and they can issue a warrant for your arrest if you do not show up in court and answer the subpoena in front of a judge. Okay. It's just the 17 questions. Just fill them out and give them to them. Okay. But otherwise they're going to bring an enforcement motion. And if you don't show up in front of the judge and fill it out there in the courtroom, then they may issue a warrant for your arrest. Now, it's a civil contempt. People don't tend to get arrested on them. Okay. It's not like they come looking for you. It can happen though, but it usually does not happen. Okay. So that's why, but there is no debtor's prison or anything like that. Okay. If they, some creditors will try to get you to pay. Again, Social Security exempt. The actual site is 42 USC section 407. That's USC stands for United States Code. Social Security is exempt. IRAs are exempt. 401ks are exempt. Pension plans are exempt. There's case law and there's statutes saying they're exempt. So if you have those exempt funds, they're not going to get a wage execution. If you're working, okay, and you're worried about a judgment creditor getting a wage execution, you have to take home at least $217.50 a week take home before they can get any kind of wage execution. So if you're under that, they can get an order, but they can't get any out of your wages. If you're over that, they can get 10% of your gross salary and no more. Only one creditor at a time can do it. They cannot all piggyback and get 10%. So if I have 10 judgment creditors, they can't all get 10%. So that my check is zero. Okay. So that 100%. First in time, first and right. So the first one to get a judgment and get a wage execution of my wages and get a bite of that apple. Okay. They stay in there till they're paid off. The other ones cannot jump on that are judgment creditors until first in time, first and right. When the first one's exhausted, then maybe the next one can jump in, but only one at a time. Okay, if you own a house, a creditor can sue you, get a judgment. They can docket a judgment, and it's a lien on the house. All right. Technically, they could foreclose on its lien. This is not a mortgage. This is someone that sues you, let's say on a credit card, and gets a judgment. But they're very rare. A condo association, though, will, if you owe fees and stuff, will foreclose a lot of times. But a credit card that you owe and they sue you and they get a judgment, they can docket that judgment in Trenton. It's a statewide lien on any real estate, and it sits on your property until you sell it or you die, and it's administered. But technically, if they don't want to sit on it, they could try to force a sale if there's no other way of collecting on their judgment. They don't tend to do it. Nobody tends to do it anymore. I have seen it done, but it's so rare. I've only seen it done maybe once or twice in 30 years of doing this consumer cases. Okay. Okay, so if you had these protections because you have, retirement income or assets, then you don't need a file of bankruptcy for a fresh start. All right, you don't need it. Save it in case you do need it down the road, because that discharge you can only get every so often. Okay, so I guess we're at the end, right? We're doing pretty good. Got 10 minutes left over.
Thanks so much. That's so much valuable information. I want to offer to people to put in the chat or the Q&A box if you have any questions for Gary about anything you've heard today. While you're thinking of your questions, I know sometimes it comes up. Are there ways to stop these creditors' harassment other than by filing bankruptcy? I mean, suppose I do only have Social Security retirement income, but they're harassing me to make a payment plan. Is there anything that I could do, Gary?
There is under what's called the Fair Debt Collection Practices Act, which is federal law. Presently, what you can do is you can send a letter. It's called a cease letter. And what you do is you tell them to stop calling you and stop dunning you or writing you letters over and over. All right. That only works for collection agents. All right. So it doesn't work for a primary creditor. So to give you an example, let's say American Express is bugging me on my credit card. They are not a debt collector. They're the primary creditor, but they sell that debt because they defaulted on it. I missed the payments and they sell it to somebody else to collect. That's a debt collector. Or they hire an attorney to sue me. That attorney is a debt collector. So if they are bugging you, or if a collection agent is bugging you, you can send them a cease letter, all right, under federal law, and say, please stop contacting me. I'm not admitting that I owe this debt, all right, and I'll take care of it when I can, or something to that effect. But you don't admit that you owe it. You never do that, because you may have used a credit card and owe on it, and you may have a complete defense to it that you're unaware of. You should talk to an attorney before, so you don't admit to owing it. You could just say, I'm writing to you with respect to my account, such and such, and with American Express. Please cease contacting me pursuant to, it's federal law. It's basically 15, I can cite it, but it's, I don't want to bother citing it specifically, but and please stop contacting me. And then they have to stop contacting you under federal law. If they attempt to contact you again, you actually have a cause of action to sue them to up to $1,000 statutory fine for violating it, and also attorney fees if an attorney takes a case and sues them for you. So I don't hope that answered your question.
So we do at Legal Services of Northwest Jersey represent clients in certain kinds of bankruptcies, right? You do them?
Yes, we do 7s, and we do some 13s. A lot of times people that have enough money to do a 13 plan may not be eligible for us because they're over our income guidelines. But we do that.
What kind of information should I put together to provide to my bankruptcy lawyer?
What kind of information?
Yeah, I mean, like I said, we need to collect pay stubs or
you have
tax
to
returns?
you have to disclose your income. You have to have at least 2 years of tax returns that were filed, the most recent tax returns. You have to disclose all your assets. You'll need proof of your last 6 months, your prior 6 months of income. You have to have proof of your bank statements to show what were in your bank statements, because they may want to investigate that to see if you're hiding assets, because you're listing everything down on your petition. You say, I have $1,000 in my checking account at the time of filing. I have $2,000 in my savings account. I have this, I have that. I mean, literally, you list everything on the petition. You cannot fail to disclose, and you must list all your creditors. You can't pick and choose. I'll have someone say, look, I owe my brother money. I don't want to list them down. I'm a bankruptcy attorney. I'll tell them, look, you have to list them down. If you deliberately leave information off, you are swearing under oath, under penalty of perjury, that this is all your information, all your assets, and all your liabilities. If you leave stuff off, you've actually committed a federal crime. Some people may be aware of, what was it, the Housewives of New Jersey or whatever, and the husband went to federal prison, and I believe the wife did for a short period of time. That was failure to disclose assets on their bankruptcy, which was a bankruptcy crime. The result is, one judge called it the equivalent of bankruptcy death. What does that mean? It means all the debts that you listed were not discharged and never can be discharged, all right, because you committed a bankruptcy crime, and you can wind up going to jail, right? I think you can get up to 5 years in prison and a $250,000 fine. So you can get both, $250,000 fine, 5 years in the can, and lose all, and never be able to discharge any of the debts you listed prior to filing that. So it's dangerous. You have to list everything. And
so Gary, we have a question. So is it possible to get a consultation to assess, with your attorney if a bankruptcy is advisable. I mean, if a client were eligible, they could call up, before they have all their documents in hand, before they actually know what they're doing, they could come in and consult with you or one of our attorneys about bankruptcy. Is that right?
Exactly. We don't require you to show all that paperwork. You come in, you tell us what your income is, you tell me what your debts are. You might tell me, look, I've been sued, or I have a judgment, I have this. And then from there we say, okay, we do an analysis and say, look, you don't really need to file. You can file, but you don't need to file. Or yeah, we can give you relief. You need to file it. You can file a Chapter 7. We can protect that, that old car you have that you're worried about, or I can protect your bank accounts because we can use the bankruptcy exemptions and stop these people from harassing you and stop the calls. And we can also protect these assets that we probably couldn't protect under state law, but everyone is a case-by-case determination. But you don't need all that information. You don't need to bring in, all that information with you. It's a consultation. You should just be able to have that information, readily available for you in your head.
One way we could get that information just about our situation is probably getting an annual credit report, right?
You can do that, but not everyone is on your credit report. Not all creditors report to credit reporting agencies. You can get a free credit report once every year. It's a right under federal and New Jersey law. You can get it at www.annualcreditreport.com. It doesn't cost anything, once a year.
Okay. And let's see. Unpaid back rent, is that something that could be discussed for bankruptcy protection?
It can. There's some wrinkle that may be involved, but normally there is an argument that back rent is dischargeable. I would think the fact that some people have lost income due to COVID and stuff, and if it's continuing, I would suggest that they wait till after to file a bankruptcy, because post-petition debt's not dischargeable.
I have another question about whether a bankruptcy would affect a financial aid application for children's education, and how else would it affect my credit as well?
There's not I can't give you a specific answer to that. A bankruptcy shows in a credit readout for 10 years. It is a negative inference or impact on your credit, but it doesn't mean you can't get credit again. Normally, if you're late on a payment, it shows for 7 years in a credit readout, and then it has to come off. If it doesn't come off, you can demand that it comes off under federal law. Bankruptcy is for 10 years. Some creditors will actually say, oh, you filed a bankruptcy. I see it's on your credit report. And you filed a Chapter 7. And I know you can't file another Chapter 7 for another, what, 8 years. So I'll give you that car loan. It'll be secured to the car. And if you don't pay me, I can repossess the car and sue you for the deficiency after it's sold, if there's anything that's still owed. And I know you can't file another Chapter 7 because you just filed one and you have to wait 8 years. So sometimes a creditor actually might maybe look at you in their eyes as a better risk because you now owe no debt, you wiped it out, and you can't file another one for a while.
So I want to thank everybody for your attention and Gary for your help. I have on the screen ways of contacting us. Please feel free to email me if there's just a question you want to follow up on something with Gary about something you heard today, and I can get your question to where it needs to go. Please do call our number 908-231-0840 to apply for services if you would like a consultation about bankruptcy or any of the other services that we talked about. And again, if you have other questions about how to access legal services, please do email me. And our website has a lot of valuable information. lsnwj.org has lots of referral information for consumers. If you look for the resources under the consumer team, you'll see lots of places you can go to research student loans, consumer advocacy organizations, and so on. So we hope to see you again, hear from you again in the future, and sign up for our mailing list so we can let you know about other webinars we have. Thank you so much for your time, Gary. Very useful information.
Take care, everybody.
Bye-bye.